entirely both duplicative and potentially privileged if she's going to come in and say, as the attorney for one of the Kowalskis, I was sending warnings.
Well, it's not your privilege to be concerned about.
Sorry, go ahead, Mr. Rowland.
It's not only that, Judge. These matters were squarely in front of Judge Hayworth in the dependency action. She was dealing with Judge Hayworth in the dependency action. And the matters that are being alluded to were brought to Judge Hayworth's attention in that dependency action and dealt with at that time. So this is a matter, once again, of us going into matters that were before the dependency court that are not only duplicative of what we've heard already, but also were before Judge Hayworth and subject to his jurisdiction at the time.
Well, obviously, if it's talking about the dependency court, I'll shut it down, just like I've been on everything else.
We have big red lettered things. Don't ask this. Don't get into this on our desk.
But I mean, if there's a notice that's separate and apart from what was transpiring within the dependency court, perhaps that is relevant. Maybe it's cumulative, maybe not. I don't, until I hear it, I won't know.
And who is the other gentleman that they're having coming in for?
Brian Gillis, he would be
Was
similar.
he the attorney for DCF?
He was an attorney for DCF at the time.
And what is he going to be testifying to?
Again, Judge, off the top of my head, you remember Mr. Gillis?
One issue would be the issue that arose with Catherine Beatty's email that we tried to have admitted and the factual assertion that there was a delegation.
The email you sustained?
Yes, sustained it with the additional instruction that the defense could try to prove up a delegation.
I think it's also important to note that I do not believe Mr. Gillis was actually working on the Kowalski dependency case, and he is currently Deborah Salisbury's practice partner.
Was he the DCF attorney at the time?
I would defer to Mr. Whitney on that. My understanding was he may have worked for DCF, but he was not staffing the Kowalski case.
This is the point, Judge. Yeah, we have no information that suggests that he has any involvement in this case, except to the extent that he used to work for DCF back then, but had no knowledge or involvement in this case. So when he's been injected in the case before, it's been offering opinions about what DCF should have done or what should have been done in this situation, like a de facto expert of some sort, but yet he's never been listed as such, and he has no personal knowledge of events here that we're aware of.
Are we calling him for the dependency action? Because you know that's not happening.
I know that is not happening.
So what is he being called to say?
Without my notes, I can't tell you specifically, but I will reevaluate whether we can call him and take any risk with it. Honestly, Judge, I've been concentrating, trying to get ready for this witness and get things going and dealing with their motion.
Have we turned over the exhibits that we're going to use tomorrow?
Yes, Kelly Perry takes care of that. Can we check and ensure Kelly Perry is?
Yes, they were sent at 12:01.
Okay. Anything else, Mr. Hunter?
Well, two other matters. One is, I really would like to hear some explication of what we're doing with Mr. Gillis, because otherwise, we're floundering around all night trying to figure out what this guy's going to say with no indication of what he in fact is going to be proffered for, and just wasting a lot of time. And then the second thing is, did I hear Jessica Stevens on the list for tomorrow?
Just Blackrick.
Jessica Blackrick. She is with the Guardian Ad Litem program, but we don't know what she's being proffered for, and if it's a Williams Rule situation, we're going to have.
It's not Williams. It's not Williams Rule.
Okay. So for those two witnesses, why don't we have a discussion after the jury leaves, before the lawyers leave, so we know this way somebody, if your law partner can scan your notes and send them to you, that
Yes.
way we can have a more intelligent discussion before everyone leaves here today, so we can be more targeted and focused tomorrow.
I understand. Oh, one other thing for the record, Judge. When I said withdraw to 453, That was the last exhibit that we were discussing there. I think it was 277, 453. That was
The one
just
with
as,
words all over the place.
say again?
It's the one with words all over the place.
Yes, we weren't withdrawing that completely forever. We were simply withdrawing it for the purposes of this witness.
Judge, I apologize for this request, but I've looked at their redacted exhibit and I didn't take the best of notes. And can I ask the
Let me
court to
see it.
look at it to
Yes,
make
please.
sure that it's in conformance with the court's ruling? And I don't know about the other one. You only gave me the one exhibit.
The top two are fine. The bottom one, and just so the transcript's clear, I'm looking at 2277-630A and 631A. The bottom one looks like what I said this morning, but without being able to compare it to the one I actually ruled on. But it looks what.
Would you like me to publish the other one?
I mean, if you could pull up the other one, but I think so I can see the underlying. But I think this is what I said.
Would you like to see 628, 629, or the other ones?
If I can see the original without the A, the 628 without the A.
Got it. Just a moment.
But Ms. Crows, this does look.
I wasn't suggesting it wasn't, Judge. I just wasn't clear and didn't want it going in.
Just a moment.
No, unredacted.
Yeah, this conforms with what I wrote earlier today.
All right, thank you, Judge.
Thank you. Anything else, or can we bring the jury in?
I'd like to proceed.
Let's bring in the jury.
All rise, jury sanctuary.
Okay. Welcome, members of the jury. Please be seated. Did you have a good lunch? Yes. Okay, glad to hear that. I want to confirm while you're away, you did not discuss this case amongst yourselves, you did no investigation and received no information. Is that all correct? And I want to confirm while you're away, you reviewed a whole bunch of media about this case. No, great. Has anyone approached you about this case since you were last with us? No. Mr. Anderson, your next witness, please.
May it please the court, I'd like to call Dr. Joseph Corcoran.
Stand here, face the clerk and raise your right hand.
Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but?
I do.
Can you please state your name for the record?
Yes, sir. I'm Joseph Corcoran,
MD,
DO.
DO. And where do you live?
I live in Tampa, Florida.
And have I asked you here as an expert in hospital administration to advise the jury on your review of the policies and procedures at Johns Hopkins All Children's Hospital during the relevant period?
Yes, you have.
I'd like you to give the jury the background, a little bit of your background training and experience for offering opinions here today, particularly well, why don't I let you start?
Good afternoon. So I'm Joe Corcoran. I am an OBGYN by background. After finishing my residency in Philadelphia, I practiced in Sarasota for about 12 plus years, from 1991 to 2003. I'm board certified by the American College of OBGYN. I spent my first 3+ years working for a large practice. In March of 1995, I started my own practice with the idea of keeping it small and boutique-y. That didn't last very long, and the practice actually grew fairly quickly. By the end of my term with the practice, I believe that we had 3 physicians, 3 nurse midwives, and 4 nurse practitioners serving a variety of offices, one of which was here in Venice. The main one was in Sarasota near Doctors Hospital. In 2003, shortly after I became a dad, I had what should have been routine back surgery. There were complications after the back surgery that ended my clinical career. I was unable to continue to stand, bend, lift, twist. Obstetrics is a fairly physically demanding specialty, even though the babies are fairly small. So it took about 2 years for me to get better, and I did that recuperation at home in Sarasota. In 2006 or 7, I started a business education master's program at University of Florida in the Warrington College of Business. I graduated with a Master's of Science in Entrepreneurship and Innovation. Shortly after graduation, I was recruited to a healthcare think tank in Washington, D.C., known as the Advisory Board. It's been around since the early 70s and is now part of Optum Healthcare. I joined in November of 2008. My first day on the job was the day before we elected Barack Obama as president. So it was really kind of neat to have a front row seat to the development of the Affordable Care Act. I had nothing to do with the legislation. We actually helped hospitals and large medical groups know how to change in this new paradigm. I was with the advisory board through the beginning of 2013. At the end of 2012, just prior to the election between Barack Obama and Mitt Romney, I was asked to deliver an address at the Longboat Key Club in Sarasota, talking about what would a second term of Obama versus a first term of Romney look like for healthcare. There were some executives from HCA in the audience. A conversation started that evening that ultimately led to them offering me the opportunity to work with HCA Healthcare. HCA Healthcare is a for-profit hospital company. It currently has about 180 hospitals, I believe in 20 or 22 states. So I was offered the opportunity to become the chief medical officer of Brandon Regional Hospital in suburban Tampa. It's about a 350 to 400 bed hospital at the time. I was in that role from 2013 until 2018.
Did Brandon, I'm sorry to interrupt, did
Yes, sir.
Brandon have pediatrics as well?
Brandon always had a pediatric capability. But during my tenure, we actually developed what we referred to as a hospital within the hospital, so that we had a dedicated pediatric emergency department that had a separate entrance from the adult emergency department. And we had a dedicated floor for pediatric patients, including a pediatric ICU. And of course, being a heavy OB hospital, we always had a neonatal unit as well for newborns.
Please continue from there.
Thank you. So in the fourth quarter of 2018, based on some progress that I had a hand in at Brandon Regional, I was given the opportunity to assume a larger role within the company. And for better or for worse, that included a move out west. I became the division chief medical officer for the Far West Division, which has responsibility for about 35 cares of site total, but 5 acute care hospitals in the state of California, 3 acute care hospitals in Las Vegas, Nevada, including Sunrise Hospital, which is about 800 beds today. If I'm not mistaken, the Sunrise Children's Hospital, which again has a separate entrance and a separate emergency department, accounts for 206 of those beds. I was in that role for about 3 years, including when the nation learned about COVID. One of our hospitals in the Silicon Valley actually had patient number 2 in the whole country. So we were kind of winging it. We were figuring it out. And a lot of what we did in managing the early cases in California and some in Nevada actually set the foundation for how the rest of the company managed COVID across as it spread from the West Coast. I was in that role for about 3 years. I left the role because, quite simply, it came down to a job that I loved and a family that I adored. My wife and my 2 kids were never able to move out west, so I was commuting about 2,000 miles, 5 hours by air. My kids are my world, so that became unsustainable. So at the end of 2021, I moved back east. And in the early part of 2022, I accepted an opportunity to step away from full-time service to HCA Healthcare and take on the opportunity to serve interim roles. So they would drop me in basically as a consultant, and I would work, 3 months at a time, engaged at a specific hospital trying to address more specific problems.
So did Sunrise Hospital, can you elaborate a little more on what your job duties were there at HCA in the Western Division? And particularly, Jerry would like to know about Sunrise Hospital and the other pediatric units that you were involved in.
Yeah, so Sunrise Hospital is a very large safety net hospital. As I said, it's over 800 beds today. The night of the 1 October shooting, you may remember where there was a sniper at the Mandalay Bay Hotel. The night of that shooting, 100 patients were taken to the county hospital, the old Clark County General, which ultimately became University Medical Center. They accepted 100 trauma patients and then shut off and went on divert. Our hospital emergency room took over 350 patients in that night. We always felt that we had to be there for the community. So it was very much a safety net hospital. It was, really kind of, it was off the strip. It was not the glamorous part of Las Vegas. The Children's Hospital, and Mr. Anderson, I want to make it clear, as the division chief medical officer, I had a facility chief medical officer at Sunrise, who really was more responsible for the day-to-day operations.
Did he report to you or she?
He did. Yes, sir.
Reported to you?
Yes, sir.
All right. So you were over the administrator there in terms of problem solving and operational decisions?
So my focus was always on clinical quality and patient safety. That really is job one for a chief medical officer. So I want to make clear, I was not over the entire leadership. There was a CEO who really ran responsibility for the hospital. My job was to support, lead, direct the chief medical officer at the facility, who also had the responsibility for clinical care and quality. Safety, I'm sorry.
And you said you're married. How long have you lived in Sarasota, setting aside your trip out west?
So I moved to Sarasota in the summer of 1991 after finishing my residency. I was a little bit of a slow learner. I didn't get to meet my wife until 1998, so I was single for a long time. And I lived on Siesta Key for most of that time. I met Patty in 1998. We got engaged in 1999. We got married in 2000, so we've been married a little bit over 23 years now.
And is she involved in business as well?
Yes, sir, she is. When I met her, she was helping her mom and dad run El Greco Cafe, which was a Greek restaurant down on Main Street in Orange in downtown Sarasota. And it's funny, I actually remember sitting at the intersection waiting for the light to change and saw the logo that said, where it was Greek cuisine, where Athens meets Sarasota. And I thought I wouldn't even know what to order if I ever walked in. Little did I know that I would end up marrying Patty just a couple years later. She now works with her sister and our nephew, and they have started a new chain of restaurants called The Breakfast Company. There's one in the Landings. There's one on State Road 70. And soft grand opening was yesterday for the new site across from UTC Mall.
So how did you, lack of a better term, get this gig? How did I find you to advise the jury on these issues?
So one of my longtime friends is Steve Heese. Steve is someone that I met during the Reagan administration when I was doing my residency in Philadelphia. Steve is a very smart businessman. He ultimately went on to be one of the owners of Chris Craft Boats.
This is irrelevant as invoking third parties who are not parties to this, have nothing to do with it.
Sustainments.
I'll speed it up, Your Honor.
You knew Steve Heese and...
I knew Steve Heese. We had dinner. Our wives are friends, so the four of us were having dinner. Steve actually knew Greg as his chief counsel, I believe, for Chris Craft Boats.
No objection, Your Honor.
Sustained.
That's all I had on that, actually.
We're
So
not the witness, Your Honor.
I'm not
Why
completed.
don't you let him finish? Thank you.
Exactly.
Finish the credentials portion.
Okay, all right. So in terms of operating hospitals and in advising the jury on your opinions here today, tell the jury about your practical experience in evaluating the operations of hospitals and noting where there are issues that must be resolved.
So it started my involvement in assessing and helping hospitals run smarter actually began when I was in practice. I was on the medical executive committee of Doctors Hospital in Sarasota for 4 years. I was elected as the chief of staff, but my surgical complications did not allow me to fulfill that role. After graduation from business school, as I said, I was recruited to the advisory board, which was a think tank and a consultancy. So my roles involved going to health systems, hospitals, and large medical groups, giving them business insights about how to work in this new Affordable Care Act paradigm primarily. And then for HCA, as I said, I was a chief medical officer at Brandon, which was about a 375-bed hospital, which has subsequently grown, and then had responsibility for about 3,500 beds all total between California and Nevada in my role as division chief.
And can you explain how HR, if you will, played a role, whether you were either directly involved or over and making decisions in terms of the HR departments in these different hospitals?
So I didn't have any direct responsibility for the HR department, but I did have leadership responsibility or executive accountability for the medical staff office, and that was a responsibility that I shared with my CEO. I had direct responsibility for the quality department, and I had a vice president of quality who headed up that department and had maybe half a dozen to a dozen members on her team. I also oversaw a couple of other organizations, including computer physician order entry,
were you involved in some of your roles in the development of hospital policy on various topics?
Yes, sir. So I didn't write the policy, but we met with the folks who did. That typically was somebody with a legal degree, so that we made sure that we wrote it the right way. But yes, I was involved in those conversations as they applied to clinical quality and patient safety primarily.
And some of the different policies and procedures that we will discuss here today, have you been directly involved or overseen the direct involvement in the development and management of those policies?
Well, not the policies that we'll look at today, but policies like that as they applied to
Obviously not
our
these,
hospitals. Yes, sir.
but in other hospitals.
Yes, sir.
And then, in terms of your as Chief Medical Officer in Brandon Regional Hospital, then, can you explain your role in terms of overseeing or developing hospital policy and procedures of the type that we'll be discussing here today?
Yes, sir. So, for instance, one of the things that we did, aside from just writing policy, was actually working on performance improvement. So, for instance, shortly after I started at the hospital in the early part of 2013, we participated in an effort to improve how we were doing with sepsis, which is an overwhelming bacterial infection. When I joined the hospital, if you were diagnosed with septic shock, there was a 44% chance that you would die rather than be discharged home. That was unacceptable from a clinical perspective. Average nationally is about 30%. Before the end of the year, we actually worked as a team, and I had a part in leading that team. We worked as a team to put in new procedures based on what evidence and data showed us was the right path. We created guardrails for our clinical teams to stay between.
What's a guardrail?
That's my term for it. We said, look, the data and evidence says that this is acceptable and this is acceptable, and there's a range, right? So I think about it as guardrails, and we leave which lane to be in. We leave that up to the physician based on their knowledge, their skill, their education, their judgment. But we know that if you stay between the guardrails, the data and the evidence points us to the patient is more likely to get the favorable outcome that they want and we want for them. So we were able to lower our mortality rate from 44% to 24%. And we maintained that performance for several years in the mid to low 20s.
And can you explain your involvement with the standards that you'll be speaking about today? They're called CMC or CMA?
CMS?
CMS standards.
Yeah, so, lawyers frequently talk about standards of care, and that's a legal definition about what is expected a physician to do when treating whatever. Sure.
Continue, Mr. Anderson.
And insofar as the CMA standards, based on the court's ruling, I want to ensure that we just stay involved with your knowledge of the development of them, any participation you had.
Sure, and it's CMS,
CMS.
Center for Medicare and Medicaid Services, which is the federal organization that oversees Medicare and Medicaid spending. So I had nothing to do with developing the CMS standards, but these really are there's a book referred to as, well, titled CMS Conditions of Participation. And these are the standards that every hospital is held to if they want to participate.
Yeah, I know.
Sustained.
Yeah. We can't go into the operation of them, just your background in terms of actually learning about them, using them, developing them.
Understood. Thank you. So the CMS standards were what I, as a practicing physician and a physician medical staff leader, was held accountable to. The standards were also what I was held accountable to as a chief medical officer, to make sure that my hospital was meeting those standards.
Objection is sustained.
I'm sorry.
So, for the purposes of this testimony, let's stay away from the CMS standards and simply go with your background, training, and experience on this.
Yes, sir.
So, what did you review in connection with offering opinions here today?
I was provided with a variety of documents, which I've listed out in this.
If you could give the jury just an overview of everything that you'd received towards offering opinions here.
Will do. It's quite lengthy, but it's multiple depositions from some of the treating physicians, from Catherine Beatty, some documents from Johns Hopkins variety of organizations, including All Children's Hospital. Some policies and procedures from All Children's Hospital. The medical staff rules and regulations dated February 2016. Depositions of Dr. Napolitano and Perno, Patty Condon, Jackie Crane, organizational structure, org charts for Johns Hopkins All Children's Hospital, reports from various experts.
Okay. And what was your assignment here?
So you asked me to be a part of this this litigation, this case, to really help the judge and jury understand how hospitals work. They're very complex. They're very complicated. The hospitals that I worked in, Johns Hopkins actually has another layer on top of it because it is an academic medical center which has its own kind of fiefdom, right? So I was really brought on.
Object to relevance. Johns Hopkins is not part of the case.
And if you can speak to any experiences you had where you were working with or developing things with Johns Hopkins, any one of them.
Yeah, so I'll be more precise about Johns Hopkins All Children's Hospital. I apologize. So I'm sorry, the question was, sir?
Well, That's a good point. I added on to it about any experiences you had actually working with Johns Hopkins in developing any policies, procedures, or other programs.
So I never worked directly with Johns Hopkins in Baltimore. When I was at Brandon Regional Hospital as the chief medical officer, as I said, we opened a pediatric hospital within the hospital. We actually worked with Jackie Crane, Dr. Napolitano, and other leaders from All Children's to help us build that hospital within the hospital.
For the pediatric aspect of it?
Yeah, yes, sir. It was a pediatric hospital within the hospital.
Okay. Now, so that the jury understands here, in terms of the hierarchies in hospitals, and can we bring up I guess it's now 2802, organizational chart, published, Judge, if we may.
Is it in evidence?
Yeah, it's the 2015 version we talked about.
I'm sorry, Judge, I want to go to the witness meeting. It's done for Judge.
Okay, are you finished with your credential background?
Yes.
Then Mr. Hunter can go out of here.
Good afternoon.
Good afternoon, sir.
Just a few questions at this point. As I understand it, your first billet, if you will, as a hospital executive, was at Brandon Regional Hospital?
Yes, sir. My first hospital-based leadership position. Yes, sir.
And before that, and to the present day, you had not practiced in a children's hospital outside of medical school, correct?
As an obstetrician gynecologist, yes, I have not practiced medicine at a children's hospital, and I apologize for not being more clear before.
Not a problem. And you haven't worked in a children's hospital since medical school?
That's not entirely true because, again, Brandon Regional had the children's hospital within the bigger hospital, and Sunrise Hospital has Sunrise Children's Hospital.
Okay, well, let's compare and contrast for a moment.
Okay,
Brandon Regional Hospital is a general hospital, correct?
that is correct.
Is it licensed as such by the state of Florida?
Sir, I'm not aware of the license.
You don't have any idea what the licensure classifications are?
That's outside my wheelhouse as a
Would you
CMO.
have any reason to doubt that it is licensed as a Class 1 general community hospital?
That's outside of my wheelhouse. I wouldn't even be able to comment on
Don't have
this.
any idea?
No idea.
Okay. We can agree that it takes adult patients.
It does.
That's primarily what it does, correct?
It does.
And it does adult surgery.
It does.
And the hospital within a hospital is just one floor of a general hospital, correct?
When I was there, it was limited to one floor. Yes, sir.
And that wasn't there when you started. It was something y'all developed.
That's correct.
Okay. It has nearly 400 beds.
Correct.
It's in a community as a community hospital, correct?
Yes, sir.
Doesn't have a reputation for referrals far outside as a tertiary care institution.
Actually, it does a lot of intake for some of the specialty work that it does, particularly in neurosurgery and other services that aren't maintained at most community hospitals.
And they're adult services.
Yes, sir, but we also took in transfers from newborns.
Okay. So if you had problems with a newborn, you transferred it, correct?
Well, we kept most of them at the hospital.
But if you had a complicated newborn, you transferred it to a children's hospital, correct?
For the most part, yes, sir.
Okay. Now, do you have any idea what the number of beds that All Children's has?
I believe it's in the neighborhood of 240, 250.
What is their licensure, do you know?
I have no idea, sir.
Do you know what the acuity level of the beds at All Children's are?
I do not.
Do you know how many NICU beds they have?
I do not.
Do you have any idea how many PICU beds they've got?
I do not.
To talk about your hospital in Las Vegas, you never worked in that hospital, did you?
I was in the hospital on a weekly basis, but I never had an office in that hospital.
you didn't have day-to-day responsibilities for being the CMO of that hospital, correct?
That is correct. I was that CMO's boss.
Okay. And you were over the top of him and didn't have command of the executive team, did you?
Not command, no, sir.
Okay. So you were not directly responsible for operations in that hospital. You were supervising what your employee did in that hospital, correct?
I was accountable to the work that was done there,
Okay.
but not responsible for the day-to-day operations.
Okay, that's my point. Okay, so how many beds was that hospital?
The hospital writ large is, I believe, just over 800 beds, and I believe just over 200, I believe it's 206 of those are part of Sunrise Children's Hospital,
Is it separate?
The hospital is a multi-block complex. Sunrise Children's has an entrance on the south side of the complex. The adult hospital has its entrance on the northwest corner. The emergency room is, both the adult and children's emergency rooms are on the east side. So I don't know how to answer that. They are, when you're leaving one hospital and entering the other, but there are contiguous hallways.
Are they separately licensed?
To my knowledge, they are.
And how are the licenses classified, do you know?
Again, that's above my pay grade.
Okay. What is the acuity level of the beds at the Children's Hospital?
So the Children's Hospital actually has every conceivable level of service, not level of service, every conceivable clinical service, including open heart. They have a very active open heart program. They have neurosurgical, pediatric open heart, pediatric neurosurgical. Sunrise Children's is the tertiary care hospital for the state of Nevada.
Okay. And your responsibility was overseeing the CMO of that hospital?
My accountability to my bosses in Nashville was to make sure that that hospital was running. I relied on my chief medical officer as my right hand for making sure that that happened. But at the end of the day, if something went afoul, I had to answer to it.
And when were you working with those folks?
Began in the fourth quarter of 2018, and I finished in the fourth quarter of 2021 for 3 years.
So those 3 years, but during the time that this incident took place, you were at Brandon Hospital, correct?
That's correct.
And at the time this incident took place, you had not worked in a pediatric hospital in 30 years, correct?
Again, that goes back to my clinical career.
Yes, sir.
Yes, sir.
But
Might not be 30, but more than 15.
going back to medical school?
And residency training, so up to 1991. It's pretty close. We're getting old, aren't we?
All right. That's all I have right now. Thank you.
Thank you.
Okay, now, if we could bring up, I think what I was doing here is having, okay, this isn't confusing at all, is it? All right. Let me represent to you, and for the record, this is Johns Hopkins All Children's Hospital. Well, actually, it's identified by exhibit. Where is it? I gotta get set up here again, Judge. All right, so this is exhibit Johns Hopkins, actually 2802. The Johns Hopkins organizational chart as of 2015, the year before what we're talking about here. Now,
I'm sorry, the date on mine says February of 2016.
that
Are you
that'll still
looking at
be
the same?
fine, I think. It was 2015 issued and 2016 on it.
No, we said 2016.
It's revised 2022, 2616.
All right, so it's 2016.
Okay.
Okay, can you take the jury?
Your Honor, may we approach? I'm sorry. We have an issue with this exhibit.
We're just trying to keep all our paper in a row here, so sorry about that.
But I think we've figured it all out.
I'll keep asking questions. All right, so before we get to the organizational chart, can you tell the jury a little bit of the history of how All Children's Hospital became Johns Hopkins All Children's Hospital, to the best of your knowledge?
Jeff Foundation, Your Honor.
Sustained.
Are you aware of the circumstances surrounding the acquisition, of the date and the general terms of how Johns Hopkins how All Children's Hospital became Johns Hopkins All Children's Hospital?
Jeff Foundation, Judge, if we may need to approach.
You may continue, Mr. Anderson.
Show you what's in my evidence as 2200, and ask you if this was something you relied on in reviewing the background of Johns Hopkins All Children's Hospital.
I'm sorry, can we have the exhibit number? 2300.
2300.
Yes, Mr. Anderson, it is.
Can you tell the jury approximately when All Children's Hospital became Johns Hopkins All Children's Hospital?
On April 1st, 2011,
And is Johns Hopkins All Children's Hospital part of the Johns Hopkins Hospital system? If you know.
I believe that Ms. Crane described it as the sole corporate member, JHHS.
Right.
And they did appear on the 2012 org chart. I've not seen the 2016 version.
So then let's bring up the 2016 org chart, if we have it now. All right. Oh, this is just so much less complicated. Now, can you, the first thing we'd like to know is your position at, when you were working for Hospital Corporation of America, where would you fit in this? Was there a similar position?
Well, I don't see a specific box that identifies chief medical officer on the on this All Children's Hospital Chart 1.
Right. Okay. Are there any equivalent positions there? Just to orient the jury.
Right, I'm looking. At the time, I believe they had a vice president of medical affairs, Dr. Brigitte Mueller, in 2016. I'm looking for her box on this org chart.
Let's go to the next page, please. And what I'm looking for here, and you can stop us when we. What I'm trying to look at here, and there's Dr. Miro. So this position right there.
I see it.
Okay. So let's then, if we can scroll through the next page. All right. What I'm trying to establish here is the chain of command from the president down to risk management. Okay. Now, if you can identify risk management, which I used to be able to on the old chart.
Right. So risk management is on the upper right corner. Right, thank you for the red box. Risk management is one of 5 organizations that report directly up to senior counsel, Jackie Crane. Jackie Crane then has direct reporting responsibilities signified by a solid line. One goes directly to President Chief Executive Officer Jonathan Ellen, MD. One goes to the right to JHHS, which is the Baltimore-based organization. And then one goes further to the right to the internal auditor.
All right. So in terms of the level, I see that the risk management department is separated off to report directly up to the senior general counsel.
Object leading, Your Honor.
Overall, you can answer.
Yes, that is correct. Risk management was responsible for reporting up to the senior counsel, Jackie Crane. I just want to point out, our expectation as leaders is that you not only expected your reports to direct.
Your Honor, it's not responsive to a question.
Sustained.
All right.
Thank you.
What, if anything, is different about this that you were about to explain?
I was just going to explain that there's a push of information up to your boss. Rule of thumb, never let your boss be surprised. But there's also a responsibility to pull information up because you are accountable as a leader to the organizations that you lead. You can delegate out tasks. You can delegate out.
Your Honor, some response to a question being editorial comment has no foundation.
Overrule the foundation, but let's have a question next time.
Well, why is the pull part of this so important?
So as a leader, you are responsible for what your teams are doing. So they should be reporting up to you, but it's your job, if needed, to pull information from them so that you have a clear understanding of how they are performing on tasks that you have delegated down to them.
So for the general counsel, senior counsel right here, and the senior counsel reports to the president?
That's correct.
The general counsel,
Senior counsel.
senior counsel, for your background training experience, would that he or she have a duty to pull information then on a timely basis from risk management?
Objection, lack of foundation in this organization, you speculate.
Let's just go with non-speaking objections, please.
Foundation, speculation.
Overrule.
You can get it done.
Yes, sir. In an organization such as this, you would expect that there would be a push and pull accountability.
And would that be on a reasonably frequent basis? Or constant?
Generally, I would meet with my direct reports on at least a weekly basis, if not more frequently.
All right. So if you could then tell us whether, as to this chart, then the risk management was directly reporting and the senior counsel directly pulling information up to the most senior levels of executives in this operation.
Objection, Your Honor, relatives 403, lack of foundation.
Overrule.
You can answer.
Yes. So the senior counsel should have been getting information from risk management on a recurring basis and sharing the most relevant information up to the President, Chief Executive Officer, and JHHS, and as needed to internal audit.
Now, are you generally familiar with the facts of this case, the Kowalskis versus Johns Hopkins All Children's Hospital?
I am.
And are you familiar with the facts leading to the time spent by Maya Kowalski at Johns Hopkins All Children's Hospital from October of 2016 through January of 2017?
I am.
And what was significant to you in your review of the facts there that would make this case one that the senior counsel would or should have rather had continuous knowledge of?
So this case was.
Objection, Your Honor, relatives foundation outside of pleadings.
I need to hear that question again, please, Mr. Court Reporter.
Okay, what was the significance to you in your view of the facts that there would make this case one that the most senior counsel would or should have rather had continuous knowledge of?
What was those last few words? I'm sorry.
What is this beginning of his answer? You just said, so this case was, in the objection.
Let me, Mr. Anderson, why don't you ask the question again, because I didn't quite hear what the court reporter said.
It was what we call an inartful question. What I'm asking here is, based on your knowledge of the facts, can you explain to the jury why this case, situation, whatever you want to call it, about the Maya Kowalski situation, was one that should have, if it didn't, reach the level of senior management?
Objection, Your Honor.
Overruled. You can answer that one.
Thank you. So in multiple depositions, including those that were aired this morning, it was clear that risk management was involved in helping to influence or make decisions regarding or supporting Maya Kowalski's care. The references in the depositions suggest that that was a fairly frequent conversation. On page 166 of Catherine Beatty's deposition, she describes conversations that she had with risk management that describes, quote, "This case was different."
Your Honor, I object to his parroting testimony.
Sustained.
You can simply just, without
Okay.
reading it in, just reference
Sure.
the references.
I'm sorry.
That's all right. Have you ever testified before?
No, sir.
As an expert?
No, sir.
All right. All right,
Your
so,
Honor, court, please, the witness seems to have been reading from something just a
I'm-
moment ago.
He's got the deposition.
I'd like to know what else he's got.
What do you have there? Why don't you show it to Mr. Anderson, who can show it to Mr. Humphrey.
Sure.
it's his file.
Why don't you, Mr. Anderson, why don't you go get it and show Mr. Humphrey?
I will.
Your Honor, if the court please, it's a thick notebook that appears to have
Why
select.
don't you come talk up here?
So,
Well, hold on a second. This is what we're gonna do. We're gonna put the notebook back there, but we're gonna keep it closed.
Okay.
If you need to refresh your recollection, just let us know.
Okay.
We can open it up, and then the lawyers will come up and look at whatever you're looking at.
Understood.
Okay, thank
Yes,
you.
sir.
I may approach.
You may.
Thank you. Yes, sir.
Now, where were we insofar as the reference or sources for your opinion in that regard?
I'm sorry. Can you
Ye-
reorient me?
Yeah, can we read back the last question?
You can simply just without reading it and just references.
I think the one before that.
Okay. What I'm asking here is, based on your knowledge of the facts, can you explain to the jury why this case, this situation, whatever you want to call it, about the Maya Kowalski situation was one that should have, if it didn't reach the level of senior management? And there was an objection.
Thank you. Thank you for that. So, as I said, risk management seemed to have pretty recurrent involvement in the case. That's the risk management department. The case was described by Kathy Beatty in a conversation that she cited in her testimony as being different, and discussing that with risk management and explaining multiple reasons why she felt it was different.
And so, armed with that information, what should have happened if it actually didn't?
So if this was a case that was constantly pinging in risk management, it seems reasonable that that would be shared with the executive who's in charge of risk management. That would be Senior Counsel Crane.
And so I believe we have an email here from.
Publish at this time 2277, 628, and 629 alpha, previously admitted evidence.
You may.
All right. Now, do you note here who this is from?
It's sent from Patricia Condon.
Are you aware of her position?
It indicates that she's a risk management analyst at Johns Hopkins All Children's Hospital.
And do you recognize any of the recipients?
It is sent to Jackie Crane, who was senior counsel. It was sent to Louise Barnes-Kurth, who I believe was the head of risk management at that time, and Cindy Driscoll, which is a name that I do not recognize.
All right. Now, if you would review this as to the topic here, you see where they are continuing the allegations of, quote, self-inflicted
I do.
wounds, scratches. And then, if we can keep scrolling down, and how they were asked about lesions from Mrs. Kowalski, either directly or through her counsel.
Leading Your Honor.
Overruled.
What I see is a quote from Ms. Condon. I did advise Dr. Majors to get pictures of the scratches. I need her to inquiry with Maya how she got them.
And
Just reading the exhibit once again speaks for itself.
That's not how witnesses read exhibits.
does it appear to you that Dr. Majors then from this was advising, or Patty Condon rather, was advising Jackie Crane, among others, about the incident where Maya, what the jury has heard about, where Maya was stripped down, held down, and photographs taken from her?
Calls for conclusion. Objection calls for conclusion. Relevance. 403.
Overruling the relevance, and overruling the other objections. You can answer.
This does reference a direction, advice to get pictures of the scratches.
And assume for the purposes of this question that the photographs taken of Maya Kowalski were never analyzed as part of the medical records, and an after set were never taken, and that this just appeared to be an unpleasant, highly unpleasant situation for Maya Kowalski without any authorization from parents or anyone else? Is this the type of incident that should be reported up to the highest levels?
Objection, Your Honor. As soon as facts not in evidence, can we approach on this entire matter just a moment?
Sure, you can approach. You can re-ask the question.
Thank you. Do you have an opinion based upon your background, training, and experience into a reasonable medical, do you have an opinion based upon your background, training, and experience into a reasonable medical management probability as to whether the senior level executives at Johns Hopkins All Children's Hospital were made aware of the situation involving obtaining pictures of Maya Kowalski?
Objection, foundation, and proper hypothetical.
Overruled. You can answer.
From this email, it's apparent that Jackie Crane received this email and the information was there for her to receive.
And based upon your background and training and your knowledge, what would be the appropriate thing to do if a senior level person, management level person, received reports that could be construed as a battery upon a child? What should they do?
In my experience as a chief medical officer, if I saw information like this from one of my direct reports, I would investigate. I would get involved. I would make sure that I understood what was going on.
Would you get personally involved, is what you're saying?
Absolutely.
Form and objective relevance.
Overruled.
So now, from your review of the facts of this case, can you tell the jury, and strike it, and have you had the opportunity to review various emails and other documents involving the exchange of information between Ms. Condon and Ms. Crane and others between the Risk Management Committee and the senior level to determine whether there was an appropriate response back down from senior management to investigate this further?
I have seen emails where information was shared with Ms. Crane. I've not seen any emails that there was a response directing other actions to be taken.
And assuming that these photographs were taken several days later, do you have an opinion based upon your background, training, and experience into a reasonable medical management probability as to whether this failure to investigate caused or contributed to the injury done to Maya Kowalski from the photo session?
Objection, speculation, foundation.
Yes, sir, I do have an opinion.
And what is that opinion?
I believe that it did contribute to the injury. And I think that I was here on Monday and I heard that loud and clear from Maya Kowalski herself.
And in this instance, strike it. I'll move on. I'd like to bring up Exhibit 1082, and for the record, that's the Johns Hopkins patient family rights there. And if we could go to the next page that sets forth the actual, and then if we could go down or look at the first two under expect privacy and always receive polite and now, based on your knowledge of what happened to Maya Kowalski just in this incident, do you have an opinion based upon your background, training, and experience as to whether Johns Hopkins All Children's Hospital violated its own internal statement of rights to patients?
Objection to relevance outside the pleadings.
Overruled.
Yes, I do have an opinion.
And what is that opinion?
I do believe that there were episodes that have been reported in testimony that were outside of these directives as rights that patients should have and expect.
Same question as before. Based on your background, training, and experience, if a senior member of management learns that patients' stated rights are being violated on a consistent basis, what should they do?
Objection, Your Honor. Relevance foundation outside the pleadings.
Overruled.
Again, as a leader, if I saw this kind of information coming up from one of my direct reports, yes, I would get personally involved and I would find a way to get us back on track.
And would that involve, what if any training would that involve as to the participants?
I would certainly make sure that they understood what the patient rights were that we were advertising as affording every single patient in the hospital. I would make sure that they understood what was in bounds and what was out of bounds.
And what if anything would you do to ensure that if a particular employee, in this case, let's say Kathy Beatty, rejected that training, what is your opinion based upon your background, training, and experience into a reasonable medical management probability should be the action taken with an employee in this situation who either fails or refuses to accept this training?
Objection to relevance foundation outside the pleadings. No foundation.
I don't understand the question. So I'm going to sustain it on my own. I don't understand what you just asked.
All right. Maybe I'll ask another one. All right. So what is appropriate in this circumstance for the retraining of Kathy Beatty if there was a circumstance such as you have learned, repeated behavior violating the patient's internal rights? What type of training should be undertaken in addition to just educating them on this?
Objection. I don't understand that one. Same objection as before.
I sustain.
As to the training?
I don't understand your question, Mr. Anderson. I'm sorry.
I'll move on, Judge. All right. I would like to direct you over to the farthest column right before the black column right there, and the top has got an arrow next to it, and it involves the ability to talk to another physician outside of this. I want you to assume, for the purposes of this question, that one or more of Maya's treating physicians, in particular Dr. Ashras Hanna, attempted to visit Maya in order to gain an understanding of her physical condition, how she was doing, and that he was rejected not from trying to go and treat, but simply as a visitor who was a doctor. Do you have an opinion based upon your background, training, and experience into a reasonable medical management probability as to whether Johns Hopkins All Children's Hospital violated this right that Maya Kowalski had.
Objection to relevance, assumes facts not in evidence, improper hypothetical.
Sustained.
There's been evidence of Dr. Hanna.
Sustained.
All right, now, has it come to your attention through your investigation that the Kowalskis were attempting to exit Johns Hopkins All Children's Hospital during the first 7 days of Maya post-admission?
Yes.
And has it come to your attention that over that period of time there was no court order that authorized keeping her there?
Yes.
I'd like to show and publish now Trial Exhibit 2237-005, and this is from the Johns Hopkins discharge of patient against medical advice. First, what is AMA?
Against medical advice.
Does it have the power of law?
No.
All right, so if we look at this chart down here and we continue down, from your review of it and further down, is this describing what the Johns Hopkins personnel should be doing in the event that a parent disagrees with their proposed treatment and wants to just get their child out of there?
Objection, Your Honor, relevance, foundation, lack of foundation, lack of predicate.
This is the foundation.
Can y'all approach, please? Overrule the objection. The witness can answer.
All right. If we go to the bottom of Exhibit 2237-005, now leaving out the comment on the lower right, under
I'm
the-
looking for the document. It's not up.
Okay, let's put up 2237-005.
I've got it. Thanks.
Previously. And if you look at this flow chart here, down below, in all cases, does it appear to you, and based on your knowledge of the power or lack thereof of AMA, that Johns Hopkins breached its own internal rules regarding the ability of the Kowalskis to leave simply on the basis of AMA?
Objection, Your Honor, it's leading improper predicate and relevant
discuss that.
You can answer.
Thank you. So I wasn't a party to the conversations, but there is nothing in this policy or this flow chart that should keep Maya's parents from walking out the door. It may be against medical advice, but there's nothing here.
And to the extent that they prevented in some form or fashion, either through security or through representation of some kind, the Kowalskis from leaving with Maya, and I'm talking about this period, the first week, do you have an opinion based upon your background, training, and experience into a reasonable medical management probability as to whether they violated this internal rule regarding AMA?
Objection, Your Honor. Relevance Foundation assumes facts not in evidence and fails to take into account Chapter 39 and object on the basis of the latter.
He limited to the first week, so I'm going to overrule the objection. He limited the question to the first week.
Understood, Your Honor. This is the 24-hour rule as well.
You can continue, Mr. Anderson.
Thank you.
Yes, I do have an opinion.
And what is that opinion?
My opinion is that they did not follow their own internal procedure.
And confining it then to just this week, we're talking about before there was any court intervention, do you have an opinion based upon your background, training, and experience and your review of the depositions of the Kowalskis and the facts of this case as to whether that action in violating the rules caused or contributed to harm to Maya Kowalski?
Same objection, Your Honor.
Overruled, you can answer.
Yes, I do have an opinion, and I do believe that it contributed to the injury.
I'd like to ask you, and I want to focus now, go back to 1082, if we could. I mean, I published, Judge, the same patient's rights.
You may.
All right. Now, if we look on the center column, the third from the bottom, where it discusses cultural values and spiritual beliefs, let me ask you to assume for the purposes of this question that Maya Kowalski was prevented on one or more occasions from practicing her religion, either by not being able to pray with or see her own parish priest, or by having certain materials taken from her or not provided to her, I should say, or by having this religion criticized. Do you have an opinion based upon your background, training, experience as to whether Johns Hopkins All Children's Hospital violated their internal statement of rights that they'd be allowed to practice their cultural values and spiritual beliefs?
Objection, Your Honor. Relevance, lack of foundation, the failure to take into account the interplay of DCF in Chapter 39 and outside the plea.
Overruled, you can answer.
You may answer.
Yes, I do have an opinion, and I do believe that they did not respect the patient rights that you've highlighted here.
Did you see anywhere, and strike that, did you have the opportunity to go through, if not all, the majority of the medical file during the time that Maya Kowalski was in Johns Hopkins from October of 2016 through January of 2017?
Did I have the opportunity?
Yes. Did you review it?
I did not review much of the medical record because I'm being asked not as a medical expert, but as an expert in how hospitals are meant to run.
Then I'm not going to ask the next question. want you to assume for the purposes of this question that the Kowalskis informed the physicians during this first week that they had a different type of medical treatment and they did not want to move forward with the hospital's recommendations. Do you have an opinion based upon your background, training, experience, and to a reasonable medical management probability as to whether the hospital violated the second from the bottom on the first column to right to refuse treatment?
Objection, lack of foundation and relevance, Your Honor. Rules outside the pleadings.
Overruled.
Yes, I do have an opinion, and this right clearly states that you have a right to refuse treatment except that written by law.
And have you seen anything in these records or been told in any of your investigation that the Kowalski's decision to be treated, have their daughter treated outside of Johns Hopkins violated any law?
Objection, Your Honor.
Same ruling.
I've seen nothing to the sort.
Have you become aware that there was an incident where Maya Kowalski was placed into a, quote, surveillance room and told that it was some form of EKG when in fact she was being surveyed by the hospital?
Objection to foundation, misrepresentation of the record.
Overruled.
I understand that it was an EEG,
That's right.
electroencephalogram, not an electrocardiogram. And those rooms in pediatric hospitals, it's normal for EEGs to be videotaped. That's not a practice in an adult setting.
In this instance, did it come to your attention that no actual EEG was ever performed?
There was certainly no evidence of that on the videos, that they were performing an EEG. That would involve a lot of wires, and it would be very easy to see.
All right. And assume further, for the purposes of this question, that there are no results, analysis, or barely mention of this procedure in the medical records surrounding it. Do you have an opinion based upon your background, training, experience, and to a reasonable medical probability as to whether, again, this violated Maya Kowalski's patient's rights to be able to move freely around?
Objection, Your Honor. Relevance foundation 403, it's outside the pleadings.
Overruled.
Okay.
She was placed in an EEG room and surveilled, but that apparently never made it to the medical records.
Correct.
Which would indicate to me that it was not part of the care and treatment of Maya Kowalski.
And so then, do you have any opinions as to why they were doing this?
Objection, calls for speculation. No foundation.
Overruled.
You can testify.
It certainly wasn't to treat her and help her feel better, because it was never documented. Rule of thumb is if it's not documented, it wasn't done. As to whether they were trying to just observe her activities, her actions surreptitiously, that's as likely as any reason for it.
Would you expect in that circumstance for there to have been some documentation in the medical records, some discussion of results or observations?
Objection, lack of foundation. He's indicated he didn't review the record.
Sustained.
Okay, I'll move on.
And Mr. Anderson, the next 7 minutes, let's bring us in for a good point for a break.
Yes, sir. I'd like to bring up Exhibit 3002-0002. And for the record, this is the quote consent for medical routine diagnostic procedures and treatment. May I publish, Your Honor?
You may.
It's in evidence 3002-0002. It's a defensive exhibit.
That's right.
It is. May I
I believe
publish?
it is, Your Honor. This was a carve out at his request, I believe.
If it's not in evidence, it either needs to get in evidence or you can't show it to the jury.
We don't object to it, Judge. It's not in evidence right now. If you want to lose it, go ahead.
Well, then what's this number?
3002-0002.
Okay, I'll receive that exhibit in evidence. Now you can put it up in Reyes.
Thank you, Judge. Now, if we could look at the second page of this, and you've got it up. All right. So in this, first, tell me, if you can, have you had involvement in either the development or the evaluation of these types of consents placed in the admissions packages of the patients before?
I've never developed a consent to treat. I'm certainly familiar with them as both in my professional life and as a patient.
All right, and so in this particular one, then there's a consent to treatment that involves understanding that imaging technology, videotapes, photographs, closed-circuit TV monitoring patient care may be used. You see that in the course of treatment?
During the course of treatment.
And why is that phrase, during the course of treatment, significant to any consent that the Kowalskis gave or did not give?
Objection to relevance, Your Honor.
Overruled.
So in the deposition this morning that that was shown of Dr. Perno, he said that the consent to treat.
I object to the comment about one of the
Sustained.
You can just, you don't have to reference it, just your opinion.
Okay, I apologize.
Go ahead. No, sorry.
It's been testified that the consent to treat gave the legal
No objection, Your Honor.
Does this,
Good.
I'm sorry.
Objection.
I'll rephrase. In your practical and clinical experience, is there a requirement that any such video or photographs have to be part of actual treatment in order for these consents to apply?
Objective form calls for conclusion, relevance.
Overruled.
Yes, it's clearly stated that videotapes, photographs, and closed-circuit television monitoring of patient care may be used during the course of treatment.
And so if the jury were to want to determine whether this consent had any validity, what would they want to look for in the medical records around the time of any such photos or video?
Objection, foundation, speculation.
Overrule those two objections.
At a very minimum, I would expect that the videos, photographs, etc., would be part of the medical record if, in fact, it was part of a course of treatment.
And would you expect there to be discussion or analysis of them as to the why, how, and result?
Same objection, Your Honor.
Overruled. You can answer.
Yes, I would expect that it would be referenced in a progress note. I would expect that there would be results or interpretations, just like any other test.
And so then let me bring up Trial Exhibit 2277-06. Oh, it's not. I'd like to move in Trial Exhibit 2277-068, part of the risk management file. Just that first page. I think the two of them are complete.
If I
I may inquire, was this one of the ones that we discussed?
It looks like one of the ones we discussed, but could we approach her?
Well, I tell you what, why don't we take a break? Members of the jury, do not discuss this case amongst yourselves, do not do the investigation, and receive no information. Let's try to keep it to a 15-minute break, please.
All rise. Doors exit.
Okay, the jury is at our presence. Everyone can be seated. What is this? What exhibit is this?
Sorry, I missed the question.
I need someone can put the
Oh,
exhibit.
yeah, it's 2277-068.
And sir,
Yes.
I need you to step outside, please.
Happy to, sir.
Transcript should reflect the witnesses leaving at the court's request.
Your Honor, if I go to the bathroom, I won't.
You're fine.
Thank you.
So, what is this and how are we going to use it?
Your Honor, this is a risk management note from the hospital, and it is describing circumstances of the videotaping. It's unfortunately one of the exhibits we would have used our lunch break for, but we had other issues. So, pertinent to this discussion is that it relates to the October 18th to 20th videotaping in the EEG room, which was just discussed at some length. And at the bottom, you can see the various approvers, for lack of a better term. You have Dr. Sally Smith, Dr. Deese, and then pertinent to this witness's testimony, you have an authorization from RISC. It says okay from RISC. It describes, in particular, the videotaping, and then it says no order relevant to this witness's testimony that there would need to be a progress note, a result, an order of some type for this not to be a failure by the hospital. And then it explains the circumstances of the videotaping and the rationale relevant to the consent to treatment, which is the diagonal right in there at the bottom right says able to do when no one was there. So it's reference to, well, that's it.
Notice.
Judge, we don't know who wrote this. We don't know for what purpose it was written. We don't know what these random cryptic notes mean. And this witness has testified that he's never reviewed the medical record to comment on what should be in the medical record or what is or isn't in the medical record. So I don't know what this is being offered for right now, but there's no foundation for it. There's no demonstration of who created it, for what purpose, under what circumstances, or for what intended result.
Well, let me ask you more fundamentally, because I know we've been discussing this particular issue for 2 years now. Is the hospital's position that this was a medical procedure?
Yes, sir. This was part of a diagnostic procedure. We said that from the outset.
Okay, so then what's it doing in a risk management file? I mean, this is from the risk management file, right?
This is from the risk management file. I can't tell you what this is doing in the risk management file, Judge. I suspect that they were asking if it was okay to proceed with that based on the consent that was in there, but I don't know that, and I don't know what this means. And there is evidence of physicians indicating that they wanted to do the EEG video monitoring.
And after 5 years, no one has claimed ownership to this note that happens to be in the risk management file?
We think we know. I believe it was the first lady. No, Condon. It was. I thought it was Ms. Condon. I thought it was conduct.
It'd either be, well, it could be Patty Conda, it could be Louise Burns Kirk, but
Who cares? From our point of view, it's a risk management. It's from the risk management file. It states there's an okay from risk management. It identifies people involved in it. And we're putting it in for the purposes of demonstrating exactly what the court just brought up, which is if this is supposed to be a medical procedure, why is risk management bringing in Sally Smith? Why is risk management bringing in Dr. Dees? Why is risk management involved at all if this is a fairly routine treatment or procedure?
Let me just make it more fundamental. Obviously, this is a hearsay document, but it is a statement by the hospital.
correct.
So there is an exception to it. So there is a basis for it. It clearly is relevant, extremely relevant. So I don't see how I can keep this out, Mr. Hunter. I mean, what other basis are you suggesting that I
Judge,
exclude this document?
there's no indication of what the document means, of who created it, or what the intention behind the so-called document is. I would venture to the comment that saying that this page of random notations is a document is stretching the word document a bit far. It came from the risk management file, I'll grant that, but the idea that it simply reflects someone having called risk management and been asked, is this okay, and been told, yeah, that's not, number one, it's not relevant to particularly anything other than the fact that it occurred, and number two, it doesn't give this, with these random jottings, any kind of probative value or relevance.
Well, here's where I'm just not following your argument, because this has been one of the most hotly contested issues in this case, and you're telling me that a document from the risk management file, and this is one of the punitive damage claims, talks about the video, no audio, no order, to see if she can walk on her own, suspected Munchausen syndrome by proxy, that this is not relevant? I mean, how is that possible, Mr. Hunter?
Judge, the doctors were attempting to gather clinical information. There is a notation in the chart, patient transferred to room 709 yesterday for monitoring, continues to have pain all over, but reports she was able to get more sleep last night. Her PO intake appears to be slowly improving. The demonstration is from that note that it is part of the medical record, and exactly the narrative that's being promoted is just not correct. We don't have a date on this beyond what 1, 2, 3, 4, at least a range of 6 dates, so we don't know what it was for.
Well, the jury's going to get to see it. It's highly relevant. I don't understand why we continue to talk about it. We've been talking about it for years. This is highly relevant. And
Yeah.
I mean, I guess yours and my definition of relevance isn't calibrated the same. So I just.
Assuming it's relevance, it doesn't speak for itself. So to give it to an expert to opine on before the person who actually put it in the record and can explain its contents, when, where, and how, and why it was done, I mean, this is just the wrong time to use this document.
Well, now that I am more akin to that type of argument, Mr. Oltenburn, but it seems like this document is pretty clear as to what it means. So I'm going to go ahead and admit 2277-068. Can we take a break?
Yeah.
Okay, we'll be back in 10 minutes.
Your Honor, at least when this witness is concluded, I want a special instruction on the fact that violations of internal rules and policies and things like rights and responsibilities is not a violation of the law or actionable, but it can only be used as evidence. We need a limiting instruction on what's going on here.
Absolutely. Well, I suggest on the break, get Mr. Elliott on the phone, you and he start talking about this. Okay. Thank you.
All rise. Let's go on recess.
Yes, sir.
All rise, juror is entering.
Please be seated, everybody. Okay, members of the jury, I just want to confirm while you're away, you did not discuss this case amongst yourselves, you did not do any investigation, and you did and you received no information. Is that all correct? And has anyone approached you about this case? And have you seen any media coverage about this case? No. Okay. And the doctor's taking the stand again? You can. And you understand you're still under oath, sir?
Yes, sir.
Okay. Mr. Anderson, you may continue.
I'd like to pull up trial exhibit 2277-068. Is that in? Yeah, that's in. That's the one we just got in. 2277-068. All right. Now, Dr. Corcoran, I'd like to orient you to a few phrases here. And the center bottom of the page here, there is an inscription that says "okay from risk," and then and we can highlight that. Now, based on your experience and knowledge, and I'll represent to you, this came from the risk management file. Does this appear to be a form of authorization from a risk management department, given the circumstances?
Judge, conclusion, lack of foundation, relevance.
Overruled. You can answer.
I don't have enough information to make that conclusion, sir.
Assume for the purposes of this question that in fact is referring to a risk management department. All right, so if you then look up in the top right hand, it says to see if she can walk on her own. Do you see that?
I do.
And then above that, it points and says something to the effect of no video.
Apparently in the PICU?
Right.
Right.
And then below that, it says video only, no audio.
Correct.
Right. And then if you go down here, in this box on the lower right, able to do when no one was there, I believe. And then finally, on the bottom left, it says no order dash and above it videotaping. And I'll represent to you that this is from the risk management department. Now, based upon your background training and experience, does this appear to be an analysis of a medical need or an analysis of another need to prove something, a diagnosis or whatever?
Objection, lead, relevance, foundation.
This does not look like a traditional order, which would be electronically submitted in an electronic medical record. This looks like notes taken. You said it's from the risk management department, so I would say that these are notes taken of a briefing or a meeting where it's decided based on this history, based on this need, we have the okay from risk to do videotaping without an order.
And then in the center of it, it says suspected Munchausen syndrome by proxy. I know you're not a psychiatrist or psychologist, but are you aware of whether suspect Munchausen syndrome by proxy is a diagnosis of a parent or a child?
Objection, Your Honor. Foundation, competence, relevance.
What, if anything, do you know about It's just about Munchausen syndrome by proxy.
Same objection, beyond scope.
And finally, I'll point out here in the center above, it says Dr. Smith, Sally Smith. Do you see that?
I do.
And Dr. Dees and Dr. Smith, Sally. You see that?
I see that.
And have you seen in the records where these two doctors were participating in the ordering of this video?
Objection,
If he has.
foundation.
I ask you if he has.
Overruled, you can answer.
I have not seen that specific order, but I have seen both doctors referenced throughout the stay.
Okay. And have you had an opportunity to investigate, as part of your the assignment here, the role of Dr. Sally Smith in all of this?
I have.
And did it come to your attention that Dr. Smith was the director of child abuse education at Johns Hopkins All Children's Hospital during the relevant period of time?
Objection to relevance, foundation.
Overruled, you can answer.
I believe that she was head of that program from 2015 to 2018, if memory serves.
And let's pull up Exhibit 2116. And that's in evidence, Your Honor. That's a committee, I believe. Messages. Now, if you take a look there with Dr. Smith, does it appear Dr. Smith and Dr. Paola Dees were messaging back and forth?
It does.
And so it says, FYI, we were able to move her to a video room last night. Staff has been making notes by watching her remotely. Apparently she's currently sitting in bed with legs crossed and has a laptop or something propped up on her lap.
Objection to leading.
You see that where it's written there?
I do see that. Oh.
And I'll ask you to assume for the purposes of the question that the videotaping in question occurred October 18th and 19th, 2016. And then below it, it says, we may need to try to monitor what she's doing online. I wouldn't put anything past her mother.
I see that.
Objection, Your Honor. Reading the document speaks for itself.
It's a predicate. So, if this type of communication was brought to your attention in your roles as director of, again,
Chief Medical Officer,
where two doctors were conversing in this manner about a patient and a patient's mother, what, if anything, would be your concern?
Objection, Your Honor. Speculation, foundation, relevance.
Overruled.
at a minimum, I would address their method for discussing the case and the tone and characterization of their discussion.
Does this tone and characterization, based upon your knowledge and position, both as a physician and as a medical director, does this appear to be a compassionate concern for a little girl?
Objection, foundation, relevance, leading, speculation.
Overruled.
In a word, no.
And should doctors be trying to set up their patients to see if their symptoms are correct or not? Or
I'm
real
sorry?
Or not? Should doctors be trying to set up their patients to develop, for lack of a better term, evidence or proof against them for their diagnosis?
Objection to relevance, 403.
Can you, Mr. Corridor, can you re-ask that one for me?
Should doctors be trying to set up their patients to develop, for lack of a better term, evidence or proof against them for their diagnosis?
Sustained on that one.
I'm going to leave that be for now. I'd like to pull up 2277-630 and 631A. And this is, for the record, an email between Patty Condon, who I'll ask you to assume for the purposes of this question was one of the risk management personnel.
So the transcript's clear. We're looking at 2277-630A, not
A.
Yeah.
Did I say 8?
I think you missed the A.
Yes, sir. Thank you, Judge. Now, I'll also ask you to assume for the purposes of this question that Louise Burns Kurth was the chief, I guess, of the risk management department. And I'll ask you further to assume that this involved a transfer or a discussion of a transfer out of the hospital. And finally, I'll ask you to assume that the Kowalskis would like to get the child out of the hospital, but refuse to do it to a psych patient, inpatient program, any type of psychological or psychiatric program. Now, can you tell the jury whether this type of attitude, as expressed here in this email, is indicative of a close relationship with the patient and her family to work together for a transfer, or whether this was more of a antagonistic relationship?
Objection, relevance, leading 403, assumes facts not in evidence, improper hypothetical.
Can I have that one again, Mr. Corridor, please?
Just a second. It's also beyond the scope of the pleadings, Judge.
Now, can you tell the jury whether this type of attitude, as expressed here in this email, is indicative of a close relationship with the patient and her family to work together for a transfer, or whether this was more of an antagonistic relationship?
I'm going to sustain the objection.
What, if anything, does this email tell you about the risk management position on Maya Kowalski being transferred out?
Same objection, Your Honor. In addition, vague.
Overrule on that one.
You asked about a relationship between the patient and the family. I believe you meant the caregiver and the family?
Yes, sir.
This looks more antagonistic than collaborative.
And are you familiar with the problem of a medical narrative starting in a hospital about a patient or situation?
Objection, Your Honor. Relevance 403, beyond the scope of the pleadings, and I think it's assuming facts not in evidence.
Sustained.
What, if anything, have you experienced in terms of a narrative, that is, a story based on a selection of facts and ignoring other facts to prove a point or make a point through the course of your experience in hospitals?
Same objection, Your Honor. In addition, he's used the prior question to suggest an improper question to the witness.
Sustained.
Can we scroll down, please? So, I think I'll live with the last answer. Let's proceed. Now, can we... Let's
2142.
2142, you want to like publish?
And it's in evidence,
It is.
then yes.
If you could review this and see if whether Dr. Sally Smith appears on here.
She's listed on the Standards and Credentials Committee, four names down.
All right. And did you have the opportunity?
Dr. speaks to this objection.
I agree with that.
With what?
I agree with it. We don't need him to basically read the document.
I understand, sir. I just wanted to identify that she was on that. Now, did you have the opportunity through your investigation to try to determine the role of Sally Smith in the care and treatment of Maya Kowalski?
I did.
And what did your investigation reveal?
Objection of predicate lack of foundation, Your Honor.
Overrule it.
You can answer.
So Dr. Smith was head of an outside agency, but had an internal.
I'm going to sustain the objection.
Okay. What, if anything, did it appear to you in reading through this as to Dr. Sally Smith's role at the hospital?
Excuse me, Your Honor. Object. I don't know what he's reading through. I don't know what he's being asked.
I assume you're talking about the committee list?
Yes, her overall role at the hospital based on the what we've already.
For a second, please. Objection sustained.
I'd like to publish then 2045-005. This is a statement. Actually, is this in evidence?
Yes, it's not.
All right. May we publish, Judge?
If it's in evidence, yes.
All right, I'd like you to review that statement to yourself, please, Doctor.
Thank you.
Do you have an opinion based upon your background, training, and experience into a reasonable medical management probability as to whether, based on your review of the facts of this case, Johns Hopkins All Children's Hospital lived up to or complied with the statement by Dr. Mueller?
Objection, Your Honor. Relevance, foundation, lack of predicate in 403.
Sustained.
What, if anything, did you see in this organization to indicate that there was a defined chain of, that there was a defined leadership or lack thereof?
Same objection, Your Honor.
We're going to overrule that objection. You can answer that one.
So it's the indications have been consistent that quality assurance and performance improvement was to be organized at a division level. And the divisions report up to departments. There appeared to be no system-wide approach to quality assurance and performance improvement.
What's the problem with that?
Well, for start,
Objection, Your Honor, it's vague, it's calling for a narrative answer, it's calling for a lecture. It's outside the pleadings, it's 403 violation as well.
so first, it's an expectation that I was held to every time that I was at the facility or division and participating in a regulatory survey, that we could demonstrate a system-wide approach.
Why is that better?
Well,
You can answer.
it sounds great to have everyone responsible for quality and patient safety. But we've all experienced it, that when everybody is responsible, nobody ultimately is responsible. So without oversight by a leader like a VP of quality, a VP of medical affairs, a chief medical officer, somebody to make sure that there was a consistency, you had wide standards from one division to the next, and that creates gaps where patients can fall through the net. And this, my experience in reviewing the system that the leaders have addressed and touted, is that this was really a system-wide failure that allowed Maya and potentially others to fall through the gaps.
Do you have an opinion based upon your background, training, and experience into a reasonable medical management probability as to whether the system that was set up by Johns Hopkins All Children's Hospital in operation provided sufficient safeguards to protect children in Maya Kowalski's position?
Objection, Your Honor. Foundation, relevance, 403, improper hypothetical.
Same.
What, if any, opinions have you formed about the ability of the system you just testified to protect children who are in a situation such as Maya Kowalski was during October of 2016 to January of 2017?
Same objection, Your Honor. You're reciting the same question.
I agree, it's the same.
What changes, strike that. How would this system have to be changed, in your opinion, in order to ensure that situations such as a child being allowed to, or being photographed without authorization on 2 occasions, a child having what we discussed before with the not being allowed to see her priest, having things taken from her, these type of events from happening?
Objection, Your Honor. Relevance, 403, leading. It also fails to take into account DCF and Chapter 39 involvement, and it's outside the pleading.
Overall, you can answer that one.
So the quality assurance and performance improvement function would need to be overhauled so that it was system-wide. And that's actually something that Hopkins is recognized as a leader in. So the expertise should be readily available to the team at Johns Hopkins All Children's Hospital. But that would provide a consistency from division to division, and create a safety for patients as they're being handed off from one caregiver to the next.
Do you have an opinion based upon your background, training, experience into a reasonable medical management probability as to whether the system in place provided sufficient safeguards for children at Johns Hopkins All Children's Hospital during the relevant period?
I do have an opinion.
And what is that opinion?
Objection, Your Honor. Relevance outside the pleadings, improper foundation.
But I don't think you tied it to Maya Kowalski, so I'm going to sustain the objection.
Same question as to the care and treatment of Maya Kowalski.
Same objection, Judge. The question's compound as well.
I'm going to overrule that. You can answer it.
I do have an opinion.
What is that opinion?
I do believe that the system failed Maya Kowalski and her family during her stay, primarily because the architecture was so siloed that there was no, there were gaps in the safety net that let her care fall short.
Your witness.
Good afternoon.
Good afternoon.
Once again.
Yes, sir.
Your Honor, if the court please, could I first approach the witness and ask to look at the materials he's reviewed?
Sure. Sure.
I'll get this back.
No worries.
Honest. Okay. Thank you, sir.
Yes, indeed.
If I understand correctly what you've just shown me, and what I will like to ask the clerk to mark when we get through here was a complete list of everything you've reviewed about this case. Is that right?
It is a list of everything that was provided to me. Yes, sir.
Okay. And it was provided to you grouped in, grouped by issue. Is that correct?
By date and by issue.
Yes. So in other words, if they wanted you to look at issues relating to the surveillance video, they sent you documents regarding that, correct?
That is correct.
And if they wanted you to look at corporate documents, they sent you a group of documents related to that, right?
That's how they're grouped. Yes, sir.
Okay. And if they wanted you to look at examples of Dr. Smith directing care, they sent you a group of documents relating to that, right?
Yes, sir.
Okay. And then if they wanted to have you look at particular documents regarding the surveillance video, they sent you documents related to that, correct?
Yes, sir. That's one grouping.
Okay. So do you have any idea how many pages of policies and procedures and documents have been produced in this case?
Have been produced to me
No, sir, to the
in jail.
parties that the hospital has produced,
I understand
the
that there.
plaintiffs have produced. Got any idea?
I understand the number is in the tens of thousands.
Okay. We can agree, can't we, that you didn't get tens of thousands of documents?
No, sir.
You didn't come anywhere close.
And for the scope that I was evaluating, I didn't need the entire.
Well, so that we're clear, we covered this a little bit earlier, and I'm not going to go back into what I asked you before, except perhaps by accident. But you're board certified in osteopathic medicine, but you've never held yourself out as a pediatrician, correct?
I am board certified in obstetrics and gynecology. I have a
I see. I'm sorry. I beg your pardon.
No worries, sir.
You're an osteopathic physician.
I am an osteopathic physician.
And you're board certified in obstetrics and gynecology.
Yes, sir. That's correct.
And you've never been trained as a pediatrician.
That is correct.
And you've never held yourself out as such.
That is correct.
And as far as your opinion in this case, it presupposes that the diagnosis of CRPS for this young lady was correct, doesn't it?
No, as I explained to you during my deposition, it presupposes that the proper approach should include an evaluation for CRPS.
I see. Okay. Did you ever look at any records of this young lady's care from Lurie Children's Hospital?
Not from the hospital, no.
Did you ever look at any from Tampa General Hospital?
No, I did not.
Did you ever review any complete medical record in this case?
Medical record? No.
Okay. And the depositions that you seem to have reviewed in this case, looking at your list, seem to be somewhat limited. Is that right?
Yes, sir. I think that's fair.
Okay. Well, you reviewed Sally Smith's and Ms. Beatty's and Dr. Elliott, Ms. Condon, Ms. Crane. That's about it, wasn't it?
No, sir. Dr. Perno.
Okay, Dr. Perno.
Dr. Napolitano. There were others.
There were others. Did
Yes,
you
sir.
ever review Dr. Michelle Smith's deposition?
I don't recall that name.
Okay, well, that's a good thing because she wasn't deposed. Here's what I meant to ask you: did you ever review her progress notes from the PICU?
I did not.
So you have no idea what efforts were made to transfer this patient during the first week that she was at All Children's.
I didn't review the medical record references to transferring the patient.
Okay, so you don't have any idea what they contain.
I never reviewed the medical record, so I have no insight into what was in the medical record regarding the transfers.
Okay. Now, let's go back to what you haven't looked at. Did you ever look at Dr. Hanna's records? Ever see his records at all?
Not his records, no, sir.
You never saw Dr. Kirkpatrick's records?
Not their treatment records.
Okay. And you've never seen any order in the chart regarding the EEG video or seizure monitoring, have you?
Again, I have not reviewed the medical record because that's not the area of expertise that I've been brought to assess.
Well, you've expressed some opinions regarding the EEG video. What I'm trying to find out is, have you looked at the chart to see what's in the chart about that video?
I don't think that reviewing the charts are necessary to inform the opinion that I shared a half hour ago.
Okay. But you did indicate in that opinion what you thought the chart should contain, right?
I was asked to review a memo. I shared my opinion or insight about that memo.
Were you ever provided any of the court orders regarding this patient?
I don't specifically recall seeing the court orders. I may have, but I don't recall it right now.
Going back to Ms. Beatty, did you ever see her personnel file?
No, sir.
Did you ever see any of the evaluations that she had, or annual evaluations?
Annual evaluations? No, sir.
Okay, so you have no knowledge of any of that?
Of her annual evaluations? No, sir.
Okay. And with Dr. Mueller, the VPMA, you know who she is?
I do.
Did you ever see her job description?
No, sir.
You did notice on all the charts here that there was no title called Chief Medical Officer in their lexicon.
And I pointed that out.
Okay. So you're kind of assuming where the Vice President of Medical Affairs fits in? You don't really know what her
I don't agree with that characterization at all.
well, you don't know what her job description is, do you?
The job description wouldn't be on the organizational chart anyway,
I
but
didn't
you are
ask you about
correct.
the organization. You
I
don't
do.
know-
I've never seen her job description.
Okay. So you know where the line is. That's
Well,
about all.
It wasn't represented, so I don't know where that line is, and that was
Okay.
my point.
You don't know where the line is, and you don't know where she fits in.
On that chart, you are correct.
Okay. Well, you looked at several charts, didn't you?
Well, I looked at organizational charts that were provided that apparently were from 2012, which had the position listed.
You talked about about the consent. Council put up 3002-002. Had you ever seen that before?
Not before getting involved in this case, no.
Okay. Well, there was a question about the use of images, video in this case,
Mm-hmm.
in the course of treatment, correct?
Correct.
Diagnosis is part of treatment, isn't it?
I would think so.
Okay. You'd agree with me about that, right?
Sure.
Okay. With reference to transferring this patient, were you ever aware of Ms. Kowalski denying that she wanted to take Maya out AMA? Were you ever made aware of that?
My understanding is that the objection that she had was based on the diagnosis of a psychiatric disorder.
I understand. So your understanding was that she didn't want the child transferred because the child would carry a psychiatric diagnosis upon discharge. Is that right?
I think we heard that that they didn't want to accept that as a transferring diagnosis.
Did you ever see any indication that the hospital was asked to reconsider that part of the medical record?
Again, sir, I've not reviewed the medical record.
Okay. No, well, my question wasn't really restricted to that. My question was, did you ever see any indication that this family heard, gee, you're going to discharge our daughter with this diagnosis. We want you to change the diagnosis. Did you ever see any documentation of that?
Where would that documentation be?
Could be any one of 1,000 places. I'm asking you whether you ever saw that suggested.
Only in testimony.
You heard it in testimony somewhere?
I believe we heard that Monday morning.
We heard that someone asked to change the diagnosis?
No, we heard that the diagnosis was rejected.
I understand that.
Okay.
Listen to my question very carefully,
Okay.
please. Because it's probably confusing, even to me. And I confuse very easily. But here's my question. My question is, did you ever see any indication, any documentation, any indication that this family asked that that diagnosis for Maya's discharge that they didn't like, that it be changed?
Documentation? No.
And under the client's rights you talked about, they had the right to do that, didn't they?
I don't have the document in front of me, but if it's in your hand, I have no reason to question you, Mr. Hunter.
Okay. I appreciate you having a chat with my wife.
Only if you'll do the same, sir.
Okay, deal. Were you aware of any policy at All Children's regarding images and recordings of patients in child abuse cases, child abuse situations?
Can you cite the policy for me?
I can. It's Defense Exhibit 3019-005. Did you ever see that?
Visible? Off the top of my head, I can't tell you.
Okay. Well, I'm not sure it's in evidence, so I'm going to pass along with it right now. But that brings me to another set of questions. In your experience as a CMO in Florida, have you ever worked with DCF?
That never came across my desk.
Objection.
Sustained.
Very well. Did you you told us that you had no role in preparing any consent of the type we talked about earlier. Is that right?
I never wrote the consent. We left that to the lawyers.
Didn't I understand your testimony to be that the medical staff is independent of the hospital?
The American Medical Association was granted autonomy around the time of the adoption of Medicare. So, yes, the medical staff is meant to be self-governing.
Okay. So the mere fact that someone holds a position in the medical staff doesn't necessarily reflect any position with the hospital per se. Is that right?
I disagree with that.
So you don't agree that the medical staff is independent of the hospital?
I don't agree that anyone with a position of authority, regardless of who they're aligned with, can't hold a position of influence with a hospital. A board member, a politician, a community leader.
Like yourself?
I'm neither. None of the above, sir.
Well, you were elected president of your medical staff.
I was and unable to serve, but
Okay.
that was when I was in practice. That was
That
a
was when
long
you were
time
in
ago.
practice. But if you had served,
Yes, sir.
that would not make you an employee of the hospital, now would it?
That's correct.
Let me ask you about a couple of depositions just to be on the safe side here. You've never reviewed any of the Kowalski's depositions, have you?
I have not.
And you've never reviewed the depositions of Dr. Kreisman or Dr. Kilgore?
Kilgore, I have not.
Dr. Posey, Dr. Sanchez?
I don't believe it. Off the top of my head, I can't comment about those.
Okay. Well, let me ask you about Dr. Tepa Sanchez while I've got you on the subject here.
Okay.
You talked about, you referred to the text exchange between Dr. Vos and Dr. Tepa Sanchez?
I believe that was brought up.
Okay. Do you know who Dr. Tepa Sanchez is?
From the PICU?
Yes.
Yes, sir.
You know what date she saw this patient?
Not off the top of my head, sir.
Were you aware that she hadn't seen the patient for nearly 3 months at the time that Mrs. Kowalski committed suicide?
Well, she was a PICU physician, and Maya was in the PICU in the early days of October, and that unfortunate message was exchanged, yes, 3 months later in January of the following year.
I think maybe she was referring to what she did 3 months before, not what the hospital did during the ensuing 3 months.
Can you read the text for me so I can
Well,
put it into context?
I've been objecting to that, so I'll tell you what, we'll let the jury hear that from her.
Okay.
But the point is, you never heard from her what her explanation was for what she meant in that text message, have you?
I've never spoken with her, no, sir.
Okay. That's all I have. Thank you, sir.
Thank you, Mr. Hunter.
Mr. Anderson, do you have any follow-ups?
Did counsel here show you a single document, deposition entry, or any other evidence that changed your opinions in any respect?
No, sir.
Nothing further.
Anything further? Members of the jury?
Do you need me to step out, Your Honor?
It depends. See how many questions I get.
Yes, sir. I'm learning.
John. Got what? I'm sorry, what before?
Well, Doctor, why don't you go ahead and step out? Looks like it's quite a few.
Could we mark his list while he's at the gallery?
That's fine. Thank you. Members of the jury. Well, no, this goes to Mr. Hunter. Members of the jury, why don't you step into your room back there. Do not discuss this case amongst yourselves. Do not do the investigation and receive no information. All right, so we're back to through these questions. Red number one. No, let's just get through this. And what's the name of the witness again? Dr. Corcoran. Okay, the first question is Dr. Dees and Dr. Smith still at Johns Hopkins All Children's Hospital? If not, why? Any objection, plaintiffs? No. Okay, so I'll ask that one. Next one has a couple of questions. If parents have ongoing concern regarding their child's daily care and treatment at the hospital and expressed it often to the staff, would the parents be advised as to the proper chain of command they should contact to voice their concern? The next question, were the Kowalskis told, I think it's they, could contact senior executives to voice their concern via email, Dr. somebody. Next question is, and I'll put an underline so you can tell me the name of that doctor. Next question, if medical staff works independently of the hospital, then who I don't know that word. I think it might be told them or who holds them accountable? Who holds them accountable?
Who holds them accountable? Looks like to me.
Yes, hold.
Yeah. But I don't know about the name of the doctor in that second question.
The second question?
Well, but it's via email or otherwise.
Or otherwise?
Yeah, I think it's a doctor's name, but it's or otherwise.
Or otherwise, okay.
Yeah, we're rejecting number 2 is on the basis of foundation. Yeah, we will not work. And the,
Mr. Anderson?
No objection, and if he knows, it's number 2, which I think he might, Mr. Kowalski's testimony. He can testify.
Okay, I'm going to overrule the objection to number 2 on red number 2. So I will ask it. Okay, red number 3, there's several questions. Do court orders have an effect on a patient's family rights? If a child is in custody of DCF, do the parents have the rights to consent or deny treatments during the DCF custody? Have you assisted in a case with a Munchausen by proxy diagnosis in your career? I'm assuming the first 2 are ones that ultimately I'm going to give legal instructions on and are not appropriate for the witness.
agreed.
So that leaves us the question about, have you assisted a case with a Munchausen by proxy diagnosis in your career?
Well, he's not being tendered as any kind of medical expert, so I don't know what matters whether he answers or not.
It doesn't matter to me, Judge.
So either there's an objection or there's no objection.
Objection.
No objection.
Okay, I'm going to overrule the objection and ask. And I think the last page. What is, quote, the acuity of the bed, end quote? Please elaborate, what does this mean? During defense review, the question was regarding the, is it acuity of the beds? Not sure what that word means in this question. I'm sorry?
Yeah, I was talking to myself, Judge, I'm sorry. I was bemoaning the fact I didn't define it,
So did you answer yourself if you were asking yourself the question?
pretty much.
Okay, so no objection? Is that, Mr. Anderson, no objection?
No.
Okay. Before we bring the jury back, I'm assuming this is our last witness today.
I could probably get. The GAL. How much coffee do I have?
Make sure you left for that.
Oh, see that? Yeah. Well, that answers that. That's gonna be our last.
Okay, so it sounds like this is our last witness. I'm going to tell the jury 9 o'clock tomorrow. Is that what we all decided?
Yes, and then we'll start with the video depots, and then,
The Georgia,
Why don't you get the Gardner and light them up and down and then do videos? What's up to you, Mr. Anderson?
If she wants to get back, if she wants to get home, she's gonna wanna go first.
yeah, I was just trying to take off tomorrow morning to get those exhibits together. Yeah, we can call her first, and then.
Well, we can talk about it.
let's bring back the jury.
Yes, sir.
I get it.
get the
All right, jurors at, thanks, everybody.
I was already seeing, so I sat.
Everybody. Members of the jury, just want to confirm while you're away, you did not discuss this case amongst yourselves. You did no investigation and received no information. Is that all correct? And I want to confirm that you've not been approached by anyone about this case since you were last with us. And you did not see any media accounts. Is that correct? Okay, Dr. Corcoran, the jury has several questions. First question, if you know, is Dr. Dees and Dr. Sally Smith still at Johns Hopkins All Children's Hospital?
I don't know for certain. I understand that Dr. Sally Smith has.
If you know or not.
I don't know.
Thank you. Okay. Next question. If parents have ongoing concern regarding their child's daily care and treatment at the hospital and expressed it often to the staff, would the parents be advised as to the proper chain of command they should contact to voice their concerns?
That's a very reasonable expectation, and I believe that that's the way it should work. I can't say that the system in place in 2016 provided for that.
Were the Kowalskis told they could contact senior executives to voice their concerns via email or otherwise?
I don't know the answer to that.
If medical staff works independently of the hospital, then who holds them accountable?
That's a great question. And the Medical Executive Committee, which I was a member of for 4 years when I was in practice, is responsible for oversight of the physicians for quality assurance, performance improvement. And the Medical Executive Committee has a relationship with the board of the hospital so that everyone's on the same page. I hope that answers the question.
The next question, and for the author of this one, I'm only able to ask one. Have you assisted in a case with a Munchausen by proxy diagnosis in your career?
I have not. I practiced obstetrics and gynecology, and I'm happy to say that that was not part of my experience.
Next question. What is the acute, quote, the acuity of the bed, end quote? What does this mean?
That would be a better question for Mr. Hunter, but I believe that he was referring to how sick of a patient can you care for. Some hospitals, like Venice Hospital when it was around, was a lower acuity. Sarasota Memorial Hospital takes care of sicker patients, so it has a higher acuity.
Mr. Anderson, that completes the jurors' questions. Do you have any follow-up questions?
No, sir.
Mr. Hunter, do you have any follow-up?
No.
And may this witness be excused.
Please. Although he's still under subpoena.
Okay, so you're free to go today, but you still might be called back. Okay, have a good day. Okay, members of the jury, I think this is a good point for us to stop the witnesses for today. Please do not discuss this case amongst yourselves. Do not do any investigation and receive no information. 9 o'clock the same time. We will see you tomorrow. Have a good day. Everybody.
Let me do the shot clock while I'm thinking about it. Okay, the plaintiffs consumed 3 hours and 20 minutes today. Their running total is 36 hours, 10 minutes. The defense consumed 40 minutes today. Their running total is 12 hours, 50 minutes. Are there any issues we need to address before we?
Well, just to be helpful, Judge, there were a couple of objections on the Dr. Newburgers that you had some question marks, and if we could look at those so we could get rulings on those.
Sure, and I think
have a
part of
copy for
it.
you.
Okay, that's great, but I think maybe it was a missed site or.
Well, I think it's just the way they designated it, Judge. So, Nick, can you mind looking with me?
Sure.
Okay. So on page 3, you had a question mark of your order. I'm sorry, of your,
So this is the
it's
September
actually-
22nd, 2020 deposition. And you bring up page 145?
yes. So I have a copy of that page of the depth, Judge. I meant to object 145-15, the word indeed, through line 21. So.
This isn't the right one.
So if I could, and the objection was breaching standard of care regarding Dr. Smith's role as investigator.
So you're suggesting that the lines 13 through 15 before indeed are okay by you?
Well, can I see it again, Judge? I don't think I objected to it. It was all blurred.
Okay.
My objection starts with the word.
Yeah, I will sustain starting at the word indeed at line 15 on page 145 through line 21.
Okay.
Okay.
And then the other one has to do with plaintiff's designation. You questioned on page 4. It's the September 30th, 2020 deposition. I went back and checked. They did designate page 183, line 1 to 12, which doesn't have a question. That's what they designated, Judge.
Okay, so what I put on here is I would overrule if the correct page site, so.
Well, I have the deposition for you, Your Honor, if you want to look at the page. But the line 1 is it's hanging there. There's the page before it's not designated.
Which is why I added a
Right.
question mark.
Oh, it looks like we failed to designate. We would designate the last word of the question, but we failed to designate the question beginning at page 1.
I'm okay with the question because I remember last night going back and looking at it. And,
Okay. Can I look at it real quick, Judge?
Sure.
So you want to start on page 182, line 23? Is that what you're saying?
Yes.
Okay. And then, did you want line, can I ask counsel? Did you want line 12? You designated
No,
line
that
12.
just looks to be
Okay.
sloppy highlighting.
Okay. No, that was your designation.
Well,
I went and checked.
Sloppy highlighting translated to a designation.
Okay. All right, understood. I think those were your only 2 question marks, Judge. Let me just check real quick.
Maybe I should just put an S or an O.
No, we can read sustained. But it might help your time. I do no such comment, okay. Yes, all right, thank you, Judge, that was the only question marks I saw.
Any more designations coming anytime soon, or?
I don't think so. I don't think so.
So just to confirm, council, tomorrow, Dr. Newberger by deposition, Dr. Smith by deposition, the guardian ad litem. Anybody else?
Are we doing it after or a full day tomorrow? I didn't know the outcome of that discussion.
Whatever you decide, but we just need to know on the defense side. Please don't surprise us.
I am looking to both sides. I will do whatever you all want to do, so long as you can agree.
If the depot's on the way in the morning, we can work in the afternoon.
Dr. Richards, and you'd have Debbie.
Yeah, we can take tomorrow afternoon off. Dr. Richards can be here. Might be able to get her in the morning, considering how long are those depots? I wouldn't mind taking the afternoon off, and we'll get absolutely as much in as we can in the morning. Maybe take a late lunch.
Okay, so,
Came through.
so, oh, goodness. I'm not gonna be able to have you in tomorrow until 8:45. So we won't have the ability to have any lengthy discussion. But I guess if you're playing a whole bunch of depths, it doesn't really matter. So we'll start tomorrow at 8:45.
Yes, sir. Hear that? We're starting at 8:45.
And to be clear, Judge, my understanding is the first two Newberger depths are being read in. There's only the video for the last depth.
I think someone said that there was no video for depths 1 and 2, so.
That's what I'm saying, Judge, those are being read in.
That's true. We'll have to read the first couple.
Well, I'm sure you'll have readers.
So it sounds like that's the plan, just those two depositions and the guardian ad litem, and then
So did you want to, because for a while you were talking about putting Maya and Jack Kowalski back on.
I think Thursday.
Tomorrow is Thursday.
You know, I can't take it off. We've got to put them on because we've got the damages people the next morning, Friday morning.
Okay, so tomorrow will be a full day, and then is it Jack Kowalski and Maya Kowalski coming back, or just Jack, or?
It's all three. But
All three, meaning Kyle as well?
Yes, Your Honor. But it's simply limited to the general damages, although I would like a stipulation of some kind about the liens, so I don't have to get into that with him. I will if there's no stipulation. I'll try to work out an instruction.
Your Honor, the difficulty on the liens is, that they want an instruction that basically tells the jury that they will owe the liens, if a verdict is entered. And one of the liens, which is about $10,000, appears to me to be a straight Medicare or Medicaid lien. Medicaid. And I know that they always maintain, well, we get it no matter what. The judges normally say you get it only if there's an award of medical damages on the verdict.
But wouldn't I have to do, is it an all-born hearing on that?
I mean that's why we normally put this off to the end to let the judge decide, because mostly it's legal resolutions based on things. The second one is an insurance, Aetna insurance policy claim. I've not seen the policy, and it's not like it's a hospital lien or a statutory lien. It's something out of a contract. And even then, normally these things get negotiated or resolved afterwards to lesser amounts. So
Is it an ERISA plan? Because that even further complicates it.
I don't know the answer to that.
Judge, we don't know whether it's an ERISA plan, whether it's a lien, or whether it's a right of reimbursement or a right of subrogation. And all that makes a difference. And
There's an LOP and there's two liens, as far as I know, and I believe, don't quote me on it, but I thought Jack Kowalski said he paid, either by mistake or just paid down part of one of them. The only thing I'm interested in, Judge, is that I don't get a DV on damages as to that, because a contingent liability like that is still a damage. And so if counsel is willing to go with that, then we can save all that till the end.
I'm willing to resolve the liens at the end of the case like we do in every other case.
What I'm hearing him say is that you would not move for directed verdict on that they failed to present
That.
the
Special medicals.
The damages.
And on the thing for fraudulent misrepresentation of the bills, is what we're talking about, right? Is that clear?
Right, yeah, that's what it is.
Yeah, I might move for DV on a bunch of other issues, but not on that.
So it sounds like we have the beginning of an agreement here.
Yeah, I won't move for directed verdict on that count because you don't prove that stuff up. I absolutely will not.
All right, so I don't have to put in the liens for damages for proof of the fraudulent.
Right, and
Right.
for the record further, I don't think you need to put that evidence in for proof of any of your other claims, but we may still need it.
Mr. Hunter seems to have a
Maybe not.
dissenting opinion.
I have an issue.
While they're talking, Mr. Anderson, I would imagine the cross will be relatively short if it's truly damages and we're not rehashing causation and liability, so we should be able to get through that schedule. Anyway.
I have nothing planned in terms of anything other than how did this affect?
I assume that, and assuming that's true, the cross will be short.
And what is it a cross of?
If ultimately we decide not to call somebody tomorrow, can we just send a note to the other side?
Yes, please, and thank you.
Okay.
Even if it's at 10 at night.
Okay, so going back to our possible agreement here, you've conferred with Mr. Hunter.
Yeah, I'm not gonna move for DV because they don't have proof that they paid that. And right now, I don't think they have proof that they paid anything else, but I won't move for DV on that either for purposes of that count.
Okay. So are we both sides agreeing? We have a court reporter here, we're in open court, so is that an agreement?
Yes, as I understand the defense's agreement, they will not move for a directed verdict based on the element of damages, since the majority of our damages has to do with the liens, which should be resolved, should not be put before the jury, and should be resolved afterwards. Based on that stipulation, I will agree not to approach the issue with my client as to the two liens and LOP, I believe it is. Are we in agreement?
And I concur in the agreement.
Thank you. So let's move on to the next issue.
Some concern here?
No, I was just gonna, I thought we were done.
We're finished with that issue.
I was just gonna rebroach. I didn't get who's coming tomorrow, I suppose.
Let's talk about the following week. So the following week, it's Wednesday. Is it Wednesday that we're not here?
Yes.
Okay. Are we going to be in a position, and Mr. Altenburn, to have a meaningful discussion about jury instructions maybe Wednesday afternoon? I've already kind of given the morning away for other things. I'm just wondering,
I was thinking about going back to Tampa, but yes, we can do that.
Well, I'm just trying to figure out when we're going to have time to talk about it.
I understand. I sent a draft to Mr. Elegant on Sunday saying, please redline these and send them back. And that hasn't yet. And I bet that's because he needs to talk to them and they've been busy. By the way, I've also sent him a draft of what I discussed a couple hours ago with him, and I know he needs to still talk with them, but I would really hope I could give that tomorrow morning. So, but the rest of that, it also helps mean if we get by the DV, then we know exactly what the package looks like.
Well, I am certainly hopeful that we will have rested the plaintiff's case by then, and even if we have to do DVs over lunch or go late or something.
And I think by this weekend, I'm gonna know what all the evidence is, so I can try to put together my thoughts on that. So I'm ready to go whenever on Monday.
So I just wonder if Wednesday afternoon is an appropriate time to start talking about the jury instructions, given that, I know that not all of you have to be here. Maybe it's just Mr. Elliott and Mr. Altenburn to have this discussion.
Because I don't think I'm going to need to be in the courtrooms so much when we're putting on our case. So especially if we were doing our case on Tuesday, I could work with Mr. Elliott a whole lot before that meeting.
And I could probably even handle you all on Zoom.
Okay.
If you wanted to do
If you wanted to go
That way we
to
could-
Tampa.
Yeah, we could even be in the same room together, probably, if you wanted to.
Well, you and Mr. Elliott?
Yeah.
Yeah, just so long as I actually physically had whatever you were looking
We
at.
work well together, work with us, so.
Do you think that's doable? Wednesday afternoon?
I do, but I'll send an email to Tom to see how far along he is on this as well.
Can you let me know like tomorrow so that if the answer is no, it's not doable, then I'll probably give the time away to others, but
Gotcha.
before y'all get first dibs on my time, so I just.
Yeah, I was hoping to have this done by the 20th of August, so I'd be happy to have them done on Wednesday.
Anything else?
Judge,
I was
just
just-
on Williams' rule on this has to do with Sally Smith, has to do with the parent agency, and I've got two witnesses, and they're going to say that Sally Smith walked in and did the same thing to them. She did the Kowalskis. Their testimony should take about 15 minutes each.
What is the specific issue? Because it's got to be. I don't have the list right in front of me.
Plan,
but-
motive, opportunity on 9404, substantially similar incident. So each one of these cases, in fact, one of them ended up almost identical to this, the Kushner case. And this is situations where Sally Smith walked in, either announced as a doctor or unannounced, wearing a lab coat and the badge, and then comes in, quote, examines them, asks a bunch of questions, walks out, and they never find out until much later that this was actually a doctor who was interviewing them towards a prosecution. And in both cases, of course, they did end up prosecuting, but that's not part of the question. That's just simply, the only question is, did you have this happen to you, so that we can show a plan, motive, or intent in terms of why they do it. And under 9404 and the substantially similar incident stuff, which I grant you is usually railroad tracks or things, but it would appear to be fall within that.
These are two people?
Two people.
And when did these events and where did these events occur?
When did they occur?
Yeah.
Well, actually, the Kushners happened within a year of the Kowalskis, and the other one about a year and a half or 2 years before. But I couldn't give you an exact date for the other one. I don't know it. I know the Kushner case because they're on the other side of it, and there's litigation in it.
I don't know the details of that, Your Honor, but the language in 404.2 on this is that you can get in symbol or fact evidence of crimes, wrongs, or acts that are admissible when relevant to prove a material fact in issue, including but not limited to proof of motive. I don't see motive, opportunity, intent, preparation, plan, knowledge, identity, or absence of mistake or accident. But it's inadmissible when the evidence is solely to prove bad character or propensity. And this smells like propensity evidence, that we've done this before, so we can do it again.
Well, I guess my question, because I had to pull up the statute to Mr. Anderson, was because it has to be an element in the case.
Right. It's got to be not just a side issue, but a big issue in the case.
Yeah, and
Correct.
so I'm struggling. I mean, it doesn't fit your medical malpractice.
A parent agency. It all goes to the agency argument, Judge, which is a key issue in the
But
case.
here's, and I was thinking about this the other day because I had a chance to read this yesterday. How is it that, let's say they did, this is true that it's been doing lots of other families, but how does that impact what the Kowalskis understood?
Right.
Dr. Sally Smith's role was, because it doesn't go to what the Kowalskis understood, it's really what the Kowalskis understood.
Right.
So I don't think it goes there.
I think that's two different points. As the Kowalskis understood, it goes on the detrimental reliance and how much they told Sally Smith and what actions they took based on their belief that she worked for Johns Hopkins All Children's Hospital. So I don't think the fact of identification and the plan that we argue was in place, which the defendants acceded to, was that Sally Smith would come in unannounced, and it didn't really matter, Judge, after that, what the circumstances were. It was simply that this was an ongoing pattern and plan of conduct in order to extract
But if you're talking about a parent agency, it's got to be focused on the Kowalskis and their understanding, and what experiences other people had is absolutely not relevant to what the Kowalskis understood, which is why it doesn't come in under medical malpractice. And I'm not sure it comes in, what happens to other people under any of your other counts. So that's why I'm struggling to see how this comes in.
I think under the intentional infliction of emotional distress count, obviously Sally Smith is part of that. But I'm not going to I didn't plan to ask them, were you traumatized by Sally Smith misrepresenting? They were, but I hadn't planned to ask them about that. I guess I could ask them about whether discovering the misrepresentation, the subsequent prosecution, was harmful to them, and that would place it as a similar incident.
Unless you can come up with something really strong, I'm going to end up denying your motion, because I don't think it fits under 90.404 paren 2 paren A.
Because we're traveling under a parent agency is the thing, and that's...
And it does not go what experiences other families, and I'm not saying it didn't happen, it's just what happened to other families isn't within the knowledge base of the Kowalskis, and it's really the knowledge base of the Kowalskis that matters for purposes of your parent agency.
I thought... I'll have to check that. I thought we were in on other... Let me check the plea.
So, unless something massive changes, expect that motion to be denied.
And just to buttress the record on that, there is a case called Trees by and Through Trees versus Kmart Corporation at 40467 Southern 2nd 401. It's a 4th District case from 1985. And it was reversing a civil case because something in this nature was done. And explaining this was a propensity and pattern of conduct were the same thing, and that's just a pattern of conduct, which is what I think they were just trying to explain. Thank you.
Thank you very much. Anything else?
No, but I just to quadruple check, because I'm so sorry. I was up very late last night and very early preparing for Dr. Hana again, because I'm hearing whispers and different people coming. The only people the Kowalskis are bringing tomorrow, again, are the DCF coordinator, the 3 Kowalskis on damages only, and the 2 depot designations, correct?
Ahead of time, we have sent over the list, including Deborah Salisbury.
And we're evaluating whether her testimony is necessary at this point, or she would be a rebuttal witness. But we will let you know one way or the other after I have a chance to speak with her after we get out here.
I guess the frustration with this, and I know it's very late in the day, is unless the plaintiff wants us to be doing this to them, in our case, throwing 7, 8, 9 witnesses that they know they have no chance of us getting through, it's very frustrating to hear that we now have a lineup of 7 to 8 witnesses that are going to span 9 to 10 hours that we know we're not getting through.
It's been a constant pattern of record.
Well,
but anyway.
It sounds like Ms. Salisbury is probably going to ultimately require some sort of proffer before. Right. And so I wonder if, from a timing perspective, is that something that is even doable tomorrow, given everyone else?
I think what I'm trying to evaluate is the scope of what she can say and not get into the wrong area. And I can't assure the court of or counsel the breadth of that until I talk to her one more time.
Well, what it sounds like is she should not be a witness tomorrow, perhaps on Friday, but not tomorrow. Is what I'm hearing, just from a timing perspective.
That's fine with us.
Because that means someone gets to go to bed at midnight as opposed to 2 a.m.
I'm in that program, and yes,
Okay.
we'll move her till Friday if we do decide to use her.
All right, thank you.
That's all you're on.
Thank you. Have a good night.
Thank you.